Good day to all. I'm Advocate Pradeep Shukla, practicing at Bombay since 48 years, and I have my own YouTube channel Advocate Pradeep Shukla, जहाँ पे मैंने बहुत सारे जजमेंट्स अपलोड किए जो पब्लिक इंटरेस्ट में हो. और आज जो मैं जजमेंट लॉन्च करने वाला हूँ दैट इज़ इन कनेक्शन विथ सेक्शन 138 ऑफ नेगोशिएबल इंस्ट्रूमेंट एक्ट विच इज़ ए चेक बाउंस एंड हाउ some technical mistake, the entire complaint can fail. So, the facts in this matter were that there was a business transaction. The outstanding liability was around 2 lakhs. The check given was of the 1 lakh which got bounced for a financial reason, insufficient funds, and the statutory notice was given by the advocate. Now, in that notice, what was mentioned was all ingredients of section 138 of negotiable instrument act were covered. But ultimately, in the last paragraph, the demand was made for entire outstanding amount of 2 lakhs, even though the check bounce was only 1 lakh. On the service of the notice, the statutory period was over, that's why the complaint was filed, and the application was made that complaint is not maintainable as the notice do not fulfill the requirement of section 138. Basically, the legal requirement is that you cannot say anything more than about the amount of the check bounced. Here, though, in entire notice about the amount of check bounce details were given as required under section 138. But lastly, the overall demand was made 2 lakhs rupees, which was outstanding liability. And that's why the complaint was not maintainable. That was the case. Matter went up to High Court. High Court maybe it was upheld, and ultimately the Supreme Court decided that yes. Before the Supreme Court, the argument was that though section 138 is a criminal act offense, but basically the idea was to strengthen the business, and it is on a civil liability, it is a recovery of money. But the Supreme Court says that your arguments, that technicalities should not be considered in view of the other facts of the case, that ultimately the reason for introducing this act was that the person should get the money. True, it was the intention, but when then specific introduction of an act is there, all the ingredients or requirements mentioned in the act has to be completely followed and fulfilled. Here in this case, a small mistake, lastly demanding the entire outstanding. The Supreme Court says no. You cannot say that because technicalities should not be considered for the suit and the complaint being of the recovery of money, but Supreme Court says no. When there is an enactment of a particular act, all the requirements, ingredients has to be strictly followed. Here in this case, it was not followed, only for the reason a small mistake that lastly demand was made for entire outstanding amount, and as such section 138 do not allow such complaint, and the complaint was dismissed. So be careful, don't take it lightly. What you are writing in the notice should be well considered, keeping in mind that the defense can be taken like this. Thank you. God bless you.